right. Welcome, everybody. Thank you for tuning in here and joining us. My name is Rob Del Giorno. I'm a partner here at Garfunkel Wild and chair of the compliance group, and I'm so happy to be joined by my partner, John Martin, who is the chair of our white-collar defense group here.
Thank you.
And we've got a great presentation, and one that, was initially going to start a month ago, and everyone now gets the benefit of some recent developments, John, right?
Yeah.
That have
significant.
That have really changed the game here for everybody with questions on these compensations. So let me start out with a couple of things. First of all, this is being recorded, and everybody who registered will get an email with a copy of the presentation and the slides, so you'll be able to go back and take a look at it if you need to, or if you need to drop off at any point, you'll get there. Then we'll just do the typical disclaimer. It's a great presentation, but it's not legal advice, so you can't rely on this with us as your law firm and a client. We'd be happy to help you. That requires a formal engagement and individualized advice, but those are our typical disclaimers. But I think it's time that we jump right in here, because you and I both know from what's on our desks, this is hot right now, right?
Yep. All over.
Yeah, and so let's just give you a little refresher, because it's important to understand where it's going and some defenses that haven't really been lodged yet. But this all started back in 2018, part of the Substance Use Disorder Prevention Act that promotes opioid recovery and treatment for patients and community act. They love to get support. They love their acronyms, right? So it's similar to the Antikickback Statute, that it imposes criminal penalties for knowing and willful payments of kickbacks to induce referrals of individuals. And here's what we're hitting on, right? Recovery homes, clinical treatment facilities, or laboratory, unless, of course, an exception applies. But you and I know, John, EKRA is far more reaching than the Anti-Kickback Statute, because this is an all-payor statute, so everybody is game here.
Which means the potential for enforcement is much broader, as is the potential for huge damages.
Exactly. So here's the issue, right? Although this was enacted in response to the opioid epidemic and to address related misconduct, I mean, we all remember what was going on. A lot of this out of Florida. Sponsors of the bill, I think it was Rubio down in Florida. You had these houses set up on local residential streets. They were like flop houses, and doing nonsense services, and pulling all of the recovery home, the laboratory, all this common ownership together. And it was a real... you not only had the epidemic, but you had substantial misconduct going on in the field for people just to suck money out on these poor people.
You had unscrupulous providers who were literally paying patients to check into their rehab or substance abuse facilities and agree to use all their services, in exchange for kickbacks, and it was getting widespread. And that was the primary focus of this law and this act.
Right. Sounds great, except when you threw the laboratories in here, and while there were bad actors owning laboratories down here, they didn't impose any limitation on the type of test, the referral source, the subject matter, which means that when we're talking about EKRA's application in the healthcare industry, we're not talking about substance abuse matters or the opioid epidemic. And so
we're not limited to that. We're
talking
about every lab service.
Right, and that's why we're seeing a lot of enforcement action. Lo and behold, big surprise, COVID-19 fraud, right? We're seeing the allergy testing and the genetic testing, and so they've really, had this little hole here and kind of drove a truck through it and used this for enforcement action. So for those of you out there who are, in this area or don't know, this is the statutory language. This is what's prohibited. So it's whoever, with respect to services covered by a healthcare benefit program, that's the all-payor stuff we're talking about, knowing and willfully solicits or receives any remuneration, including a kickback, bribe, or rebate, directly or indirectly, important later, overtly, covertly, in kind or in cash, in return for referring a patient or patronage to a recovery home, clinical treatment facility, or a laboratory, or you're paying any of that remuneration directly or indirectly, again, going to be important, overtly or covertly in cash or in kind, to induce a referral of an individual to a recovery home, clinical treatment facility, or laboratory, or in exchange for an individual using those services of that home, facility, or laboratory. And
so what you can see there is the B section is addressed at sort of what I was mentioning before, when they were paying actual patients, typically addicts, to check into these homes and use their services that would be paid for by insurance or the government. The A section, which includes referrals, presumably was put in there because what they would do is once they got these people in their home, they would then refer them to other companies that they own for various other services. So they wanted to prohibit paying people to come into your home and then referring them out to places that you owned so that you could profit even more off of the misery of people that were addicted to opioids.
Right. And then so here we have criminal statute with, up to 10 years or $200,000 fine or both. So we had these exceptions built into EKRA, right? We thought there was some hope there. They have 7 defined exceptions, which we don't really need to cover today, but they may be applicable to you. There's discounts, co-insurance waivers, there's, protection for FQHCs and alternative payment models. But there was, John, number 8, which was a directive, right, to promulgate some regulations.
Exactly. I mean, when this statute was passed, the conventional wisdom was that it was going to be like the Antikickback Statute, and they were going to develop fairly quickly a number of either exceptions or safe harbors, as in the Antikickback Statute, that would carve out certain well-known and not threatening types of arrangements, or at least limit the level or degree of enforcement. But as of yet, not one additional exception or safe harbor has been created, and there haven't even been any proposed within the last year or two.
Right. So for the majority of our clients in the cases where we're working on too, the compensation exception is the big one. Probably why, what everybody's interested in, and you better should be here. So a payment made by an employer to an employee or an independent contractor who has a bona fide employment or contractual relationship with such employer for employment, okay, the EKRA is not going to apply, if the employee's payment is not determined and does not vary by the number of individuals referred to the particular recovery home, facility, or lab, the number of tests or procedures performed, or the amount billed to or received from the healthcare benefit program, right? So you have an exception for the employees, but you have these conditions to that exception. And I just want to mention here, because we're getting into the compensation stuff, but there's also this personal services and management agreement exception. It ties into the anti-kickback safe harbor. Great, but this is just for those out there. Be aware, we had amendments to the anti-kickback statute, and this only applies to how it was written on the date EKRA was enacted. So to the extent anybody is looking around to try to take advantage somehow creatively of the amendments to the anti-kickback statute, no can do, my friends. It is not here for EKRA purposes.
So when you look at the compensation exception, you realize that this was focused at marketers who are paid based on a percentage of what they bring in, and they specifically, by the way that is written, much more narrow than the AKS safe harbor for employees. It doesn't include percentage. You are still in violation of the statute, even if it's an employee, if you pay him a percentage, as opposed to the anti-kickback statute, where once someone's an employee, as a general rule, the anti-kickback statute is off the table.
Yeah, and we have a bunch of lab clients, and this is where this compensation issue really comes up, because everybody knows laboratories were compensating or are compensating their sales and marketing reps, at least in part, based on a percentage of their collections, that is, the volume and value of their referrals. Those labs, John, were relying on that anti-kickback statute, or at least some of them, of that employment safe harbor to support this variable compensation, because the kickback statute has the employment safe harbor and it says remuneration of those payments. It doesn't include amounts paid by an employer to an employee who has a bona fide employment relationship with the employer for employment in the furnishing of any item or service for which payment may be made in whole or in part under Medicare, Medicaid, or other federal health care programs. Okay, that's what they were relying on, but there are issues there, right?
Right. And what this demonstrates is that in a lot of ways, EKRA is like the anti-kickback statute for laboratories on steroids. It takes away the one thing about the anti-kickback statute, that it only applied to government health programs. This applies to everything. And it takes away the employment exception, which is one of the most common exceptions that people rely on for the anti-kickback statute. So now we've taken the anti-kickback statute, as it applies to laboratories, broadened it, and made it much harder to comply with any of the exceptions.
And look, we talk about this as an exception that everybody's trying to rely on anyway, but there is this language in there about furnishing of any item or service. And so there could be, that was really contemplated probably in a time where they were thinking, we were talking about this earlier, the physicians joining a practice, what's the big deal? You can,
right.
It's money coming in that all of them were furnishing the same services. Marketers, I don't know, John.
Right. There is a question of whether or not this exception under the AKS would cover a lab paying a marketer,
right.
A percentage base. But it's sort of not really an issue anymore because it's now illegal to do that under EKRA, so
yep.
This exception isn't going to help you.
Yeah, EKRA upended all of this.
If you're paying a percentage to a marketer, EKRA prohibits it.
Yep. So, we all remember when this came out, and I'm sure many of you do as well. Everybody was, I think, confused because, right, you have this overnight legislation getting rushed through about opioids, but we have this gaping hole with laboratories. So what's happening?
Right.
So
I think there was a reaction. This can't mean what it says.
Right. Yeah, I mean, we've had decades of compensation structures like this without a ton of enforcement on it. And here we are. So the initial belief was, lobbying efforts would be somehow successful. Either we're going to amend this law, or we're going to put in some safe harbors.
Right. As I said before, the statute itself specifically provides and expects that there are going to be safe harbors. So I think a lot of labs said that eventually they're going to come up with a safe harbor that we can fit into.
Yeah, and so there was kind of this herd mentality, the safety in numbers. Those hopes were dashed when there was administration turnover, not a lot of, bipartisan work being done, and that kind of dried up. So the laboratories, kept telling us, well, we're faced with this prospect of all of our marketers and reps are telling us, they don't care. This is how they get compensated, and there are plenty of labs, as out there, ready and willing to give that variable compensation. So you also had this fear of losing those folks who really helped, establish and, anchor your business with different providers. So it's a real kind of predicament. We had, again, no published guidance, no court activity, right? So
right. The first couple of years, there were no published opinions about EKRA and its scope and its limitations at all.
Right. But then, John, here we go, right?
The first one.
Yep. So this one was, I'll let you talk a bit about this, but this is really the SG Labs case, and there was, this, you could feel a sigh of relief. Oh, somebody's interpreting this in a way that's reasonable. But this was a dispute, the contract dispute between a lab and its manager there, who was, providing sales and had a salary based on net profit, which, they had a dispute. It's the little guy, it's the bigger lab, and they were kind of squeezing him on EKRA and his compensation, and the lawsuit was brought, and I'll kind of let you talk about that.
Yeah, so this is an unusual way to sort of initially have someone interpret a criminal statute, a criminal and a compliance statute, because the government's not involved. No one got sued or prosecuted by the government here. What happened was the company was trying to justify its firing of an employee because his contract violated EKRA. And so as a result, when you don't have the government involved, you have no one who is really committed to the defense of the statute and to an aggressive defense of the statute the way the government is. You don't have the weight of the government weighing in, which always influences judges, and you don't have the quality of the advocacy that you get from the Department of Justice. So against that backdrop, this judge was looking at a big company trying to fire a guy who had done nothing wrong, but based on a change in the law, they wanted to fire him. So what the judge did is something that you see from time to time. He found a very unusual way to interpret the statute so as not to apply. He decided that if you're paying a percentage to a marketer who is marketing to doctors, not to patients, it's not a violation of EKRA because they're not individuals. And as we said, that's not crazy because the whole point of this law was to stop this sort of paying people to check into facilities, and these folks weren't doing that. They weren't going to individual addicts and paying them to use their lab. But the judge seems to have overlooked that the statute also prohibits payment to induce referrals. So this was a very happy result for the employee, and probably a lot of labs looked at this and said, well, okay, we can rely on this too. But it was short-lived.
Yeah, because enter U.S. Versus Schena here, and right out the box with this, it's kind of a wide-ranging charges in this case and misconduct, but you have your first criminal action and first challenge to EKRA. They moved to the defense moved to dismiss the EKRA counts, trying to rely on that.
Right, this was a criminal case charging a criminal violation of EKRA.
Exactly, and so they're up in the Northern District of California there. And by the way, just noteworthy, talking about the expansion of EKRA, this is about allergy and COVID testing, this case, right?
So it has nothing to do with substance abuse.
Okay. And so this is moves to dismiss those charges and relies on the SG Labs decision. And I think, I'll let you talk about this, but this one makes sense. And
right.
This is why we're telling clients don't get too excited about the SG Labs case.
Right, because this is what happens when, again, you do have the force and persuasiveness of the federal government advocating for a particular interpretation of a statute. And you do the other, as I pointed out before, you had an employee there who was, being to some extent victimized by his employer. Here, you had a guy who was doing a lot of bad things. You had a guy who was, doing medically unnecessary testing and overcharging for testing. But at the same time, he was also violating EKRA. And what this court did in these different circumstances was point to the language that says that you can't pay someone to induce referrals. And that's what they were doing. It's the same conduct that was at issue in the S&G case, but in this case, the judge focused on the correct part of the statute and concluded that the indictment was sufficient. And that just kind of shows you, you have to be real careful when you see one of these cases out of a district that doesn't do a lot of this, which is Hawaii, not exactly the healthcare fraud capital of the U.S., without government involvement and a lone judge. You see this judge goes the other way, and then I think we'll see that the government has, since this decision, has run with it.
Yeah. So that's really what's sitting out there. So we don't have a lot, but we know what we know, and here we go, right? So we're into a ton of enforcement action. We're talking about that's what's out there for published court decisions, and then what we've seen is what the government has done since those decisions. Yeah. So this one we just kind of continue with the Schena case where. And I bring this up because it's good to know this was really, he was doing a lot of things, but he was paying a percentage basis for his marketers, right? So he was out there, he's the president of this company, he engaged in a scheme to defraud his board, claiming this revolutionary new change and test with testing diseases with a drop of blood. Again, we're far from substance abuse, right?
Yeah, this has overtones of Elizabeth Holmes.
Yes, yes. And so he was convicted of setting up an illegal kickback and healthcare fraud scheme involved with submission of fraudulent claims to Medicare and private insurance for unnecessary allergy testing. And in order to obtain those specimens, he was paying kickbacks to marketers on a percentage basis in violation of EKRA. And these tests were, really expensive tests. One of some of them billing commercial insurers $10,000 per test. Well, he was convicted on conspiracy to commit healthcare fraud, wire fraud, a slew of convictions here.
As well as the EKRA violation.
Right, and so that case is pending. We've been following that a little bit to see where it's going to go. We'll see if we get some appeals out of there. But
right, you would expect an appeal here.
Yeah.
Almost every convicted defendant appeals his conviction, especially if he goes to trial. And so there will likely be a decision at some point from the Ninth Circuit. But I don't think anyone's really holding out much hope that they're going to go the other way on this one.
Yeah, and so what's interesting here is we're going to have a big juxtaposition, and this is why I'm glad you're all tuning in. We're glad you're here because, here we have this really kind of, traditional kickback misconduct stuff that a lot of us, hear clients saying, well, they're really going after the bad, just
Right.
the bad stuff.
I wasn't doing any of this stuff.
Yeah. Genotox is important now. This is a game changer.
Yeah, this is a very recent, obviously, as you can see, just a couple of months ago. And Genotox is a major laboratory with plenty of resources to fight if they thought there was any room to squeeze through the sort of uncertainty in the case law, and they did not. They actually were not, and they didn't have a lot of bad facts. They tried, when EKRA passed, they were paying on a percentage basis. When EKRA passed, they tried to recalculate it. They tried to do it in a way that would comply with EKRA. The government determined that they didn't do it well enough, that they still had too much of a connection between how much business the marketers were bringing in, and went after them and recovered $5.9 million in a settlement. And so what this shows is that the government's not limiting itself to egregious bad actors who are doing a lot of other bad things in addition to violating EKRA. They will go after major companies for simple, pure EKRA violations.
Yeah, let me tell you what really stands out also to me here, John. You and I have been doing False Claims Act cases together since the day we met at Garfunkel, okay? We've been doing lab False Claims Act cases and representing labs for as long as we've been here. This is a False Claims Act settlement, if I remember correctly.
Yeah.
It's published online. It's got 4.5 pages of admissions, okay? So you can go and see exactly what was going on. The major issues here, paying the percentage compensation, okay? And then there were what I would call kind of the more traditional laboratory, type fraud potential issues of, preset panels and over-ordering
Right.
because of the panels, including too many tests that are not necessarily medically necessary. So we're not really venturing very far into serious misconduct that we're more often used to as we've been talking about EKRA over the years. And the things that stood out to me with Genotox, which is what everybody needs to be paying attention to, is they had these relationships, they went to amend them, okay? But when they amended them, it's stuff we've been asked plenty of times. Well, maybe I can just make it a salary based on what I paid them the last couple of years or an average. No, they were tracking it. Part of the government's case here was they were tracking and comparing the flat rate salaries they ended up changing to compared to the prior percentage compensation in order to do true-ups, which is something else we've been asked about, right?
Right.
So this is some really, this is a game-changing for a need to take action, combined with the fact that you've been given a little bit of a roadmap here of what not to be doing.
Right.
And so this is a something that we started out saying you need to tune in for. But let's continue with some more of the other cases that have trickled out, because
part of the message I think from Genotox is that when you do try to comply with EKRA, when you do what we're obviously going to recommend and explain, when you do get rid of your percentage-based compensation for marketers and substitute a flat fee, you can't disguise what looks like a flat fee and make it really a percentage-based compensation. You can't wait and give out bonuses at the end of the year based on business brought in and say, well, it's not in the contract. It doesn't say that, but that's what we're doing. You can't identify those people and give them quote unquote promotions, the people that bring in the most dollars. The government is looking behind the alternative compensation settlements, compensation arrangements that are set up in response to EKRA, and they have to be, purely unrelated to the volume of business.
Yeah, look, I'll admit, this is okay for those who are out there saying, well, all my folks are employees and I set them up maybe the right way, or I've always just stuck with what I was doing. This is admittedly not a straight up employees case, but I think this is telling you and signaling to you, especially because they kind of have the flip side here, is that continue at your own peril.
Yeah.
And let's talk about a few of these other cases just to show the breadth and how it's being used. So we have the Liability case, which was a combo of, you did have some urine drug screening, so you're a little bit into the tox and substance abuse area, but it's the COVID-19 stuff. And there was a nationwide takedown, 14 defendants across multiple districts. Liability was charged with a $15 million scheme to commit healthcare fraud and paying healthcare kickbacks using his lab MedLogic. They were soliciting and receiving kickbacks for referrals of urine specimens, right. And they were also paying kickbacks. He caused a suspicion of $10 million in claims to Medicare, Medicaid, Blue Cross, and this is another one with percentage compensation, and the notice was just filed that there's an attempt to plead guilty here. So a little different, this one. If this is the Louisiana one, I think there was a percentage, after Liability MedLogic lab had gotten shut down, and they were moving it over to another lab, and that lab was paying kind of a marketing kickback, I believe, to Liability, if I remember this one right. But right. That's it's a more of the bad facts, different than Genotox, but they're pursuing them and people are pleading guilty. And then we have Muhammad, which is the patient brokering one.
Now, this is more what we were talking about kind of at the beginning, that they were, that is what the statutes were designed to go after, in that one of the things they were doing here was they were paying addicts to come to their facilities, which was clearly what this statute was designed to go after. But in addition, they were also getting kickbacks.
Yes. Yeah. This is like just an example of the more traditional. And I think Merced was the first one where, this is just, a reminder, keep an eye out on your people. This is the office manager of a substance abuse treatment clinic who was getting kickbacks from the CEO of a tox lab to send the referrals over, and he pled guilty to a violation under EKRA. It wasn't even I don't think there's a lot of money in this one, but I remember it being, I think, one of the first ones. So this one we added, remember, the Ruiz, Licata folks. This could have been EKRA easily, right? This is kickbacks, patient brokers, percentage-based payments, the genetic testing, et cetera, respiratory testing. They had everything going on. And I think, the purpose of including this one as a reminder is, hey, look, you're talking about real jail time, a real restitution. That's a reminder. You're dealing with Genotox on a civil settlement side. That's nice, but let's not forget this could have easily been one real.
Yeah, and the reality here is if the government had wanted to really go after these folks, they could have added EKRA and then added all the private insurance, and the restitution dollars would have gone up, and the sentences would have gone up, and that that's something that you're going to see where the government will bring anti-kickback cases and EKRA cases together, because either in the event they can't prove the anti-kickback, they can prove the EKRA, or if they can prove both, they can get a lot more damages if it's a civil case, or a lot more jail time and restitution if it's a criminal case.
Yeah. So this is kind of what everybody's saying. So what do I do? What do I do? Well, let's take a look. What are we seeing in the trend? Let's talk about the trends, right? So what are you seeing here, John?
Well, I mean, at first, it seemed as if the focus was on independent contractors. That seemed to be where this type of statute and enforcement was headed. And also, traditional kickbacks directly to either individuals or doctors. Also, a lot of times, and as we mentioned, these cases were being brought against people that had a lot of other bad stuff going on. These were kind of extra things that were piled on top of that. But as we pointed out, the Genotox case shows that the government is not limiting itself to people that are doing other bad things. If the only thing you're doing wrong is EKRA, you're a target.
Yeah. So you have, I know it kind of felt like we started out with the real kind of traditional, bad guys, bad actors.
Right.
But
blatant fraud.
You're still more in the independent contractor area for sure. Maybe if Genotox did it differently on the crossover, we wouldn't have seen it on that. But it's certainly you can't say the employment's not going to get the scrutiny. So to me that means what's your safest path? These are kind of the easy ones. We'll move away from your independent contractor.
Yeah, that's a red flag to the government.
Yeah.
It automatically opens the door to kickbacks, anti-kickback statute. It takes that exception off the table, and so it just automatic. It'll get you attention.
Yeah, and then you move it into bona fide employees. We're not just writing the word employees because we've come across plenty of clients who say, oh yeah, they're employee. They're not an employee. They're not meeting any of the real tests.
Right.
The IRS tests of employment or anything like that, and it's not legitimate, and it's not going to pass muster to claim any protections. And now, you really need to change the compensation structures, and those reps need to get on board because, we see it. They're knocking on doors and they're looking at these things. So what can you do?
And we haven't seen it yet, but if it gets, as the enforcement gets broader and broader, some of these reps that take in a lot of money are going to start finding themselves on the end of criminal charges.
Yep, absolutely. So, some of the easy things is, okay, move to a traditional salary. But again, don't just come and, say we're going to base it on what we gave you last year and just type it up into an agreement and we'll pop that number in. And that tracking of the past percentages for purposes of like renegotiation, no good. So stay away from things like that. You have to find a way to look for, what would be a legitimate type of salary here.
You have to avoid the pitfalls that Genotox fell into.
Right. And now you can still do it. You can still provide bonus and variable compensation, but you need to find a different way. It can't be volume and value of referrals. It's a major shift. So there's a change in the law or some other safe harbor. So we, there's some potential metrics that are available out there. There's plenty of companies who are advertising too, John, as consultants who've come up with a variety of different things. But basically, what our overall suggestion is that the problem that the EKRA presents is that you want to reward the people that are the most valuable to your business, and the people that bring in the most business are the ones that are most valuable. And if you can't measure that based on how much business they brought in, you can't measure their compensation based purely on how much business they brought in, what can you do to reward the right people? And what you need to do is figure out the people that bring that business in, the people that are your most valuable employees, what do they do to bring that in? Do they visit the clients weekly? Is that something? You can give bonuses for that. Do they attend more educational seminars? Do they do more other administrative tasks more efficiently? You build the picture of the guy who brings in a lot of business or the woman who brings in a lot of business based on how they got there, not based on the results. What did they do to get those results? And you reward what they did to get those results. Right. Obviously, goes without saying, compliantly, our best, most compliant marketers, those who are following our compliance rules and not engaging in misconduct. The big thing for anybody in the lab business is, another potential target area or metric can be getting out there and educating the clients on compliant ordering and complying with payer requirements so that you're getting, you're ensuring that you're getting medically necessary tests with, that can support clean claims, right? So what's a mess in the lab? Missing DX codes if their systems are set up a certain way, missing DX codes, missing signatures, missing patient demographics, missing, date of birth, sex, whatever it is, like encouraging or then having your marketers identify your problem clients, who keeps having these issues and tackling them and seeing improvement in their documentation coming across, or, reward people for expanding you into other territories or selling different types of tests. If you're maintaining your accounts, you're doing those things that you're talking about, those efforts that maintain our lines of business.
And retention bonuses are another avenue, because obviously the people that are productive are going to be the ones that stay with you, and so you can pay enhanced retention bonuses, because, like I say, you're going to end up rewarding your best performers, because your best performers are going to stick around the longest because they're going to get paid the most, and they're going to be the ones that you cultivate.
Right.
So that's another sort of way to, like I said, we're trying to come up with ways to reward your best performers that doesn't rely on some sort of evaluation of how many dollars or how many tests they brought in.
Now, with that or discretionary year-end bonus or make them discretionary, things of that nature, the caveat is be careful, right? Like, you would need to be doing this within the framework of a well-crafted, policy that you should have vetted and reviewed by counsel to ensure you're looking at the global picture of this compensation, that we're not just rewarding the volume and value of referral.
Right. Don't make the mistake of thinking, all right, I've got an employee and I pay him a salary, or him or her a salary of $1,000 a week, so I'm good, and then you give out bonuses at the end of the year that coincidentally tie directly to the volume or value of the business they bring in. That government's not going to be fooled. That year-end bonus has to be decided in a way that doesn't take those into consideration. But like I said, it can take into consideration the other things that these top performers typically do. They stick around long. They visit clients more. They get educated more.
To me, we try to help our clients with good, practical legal advice, which is not always the easiest when you are facing this issue. And we know I can tell you, I've interviewed way too many sales reps, as part of my cases. We know what you're dealing with in laboratories or in other lines where they're fixated on this compensation arrangement, but you're at a crossroads, and the solutions are new, they're uncomfortable, they don't feel great. There's plenty of literature actually out there that just paying for the person who brings in the most business isn't actually always rewarding the best employees.
Right.
And so it's time to be critical and to be comfortable with being uncomfortable and having to look at this and address this and work through these issues with your staff.
The risks are too great to try to, sort of put blinders on and keep going down this road when we're starting to see big dollar settlements and jail sentences for people that run afoul of the government in this context. So it just isn't worth it.
Yep. So thank you. That really brings us to the end of our EKRA Roundup, and it's been a pleasure to get to present this to all of you. I hope you've learned something, and it's making you think critically about your operations. And you can always feel free to give us a call or reach out if you'd like to chat about it some more, or if you need some help with your operations. So thank you all so much for your time.
Yeah, thank you. Take care.